Greetings, everyone. I am Jacob Stein, and I'm excited to be here with you for the next hour, talking about offshore asset protection planning. So first of all, I would love to make this presentation as interactive as we can possibly make it in this setting. You have the ability to ask me questions. Please do so. I will be checking for questions throughout the presentation. And the questions can be on anything that I'm covering, anything you would like me to cover, something that you've always wanted to know. This is for you guys, so you let me know what you would like me to talk about or dive in deeper, and I'm happy to do so. Let me start off by introducing myself for those of you who have not taken my courses previously. So I'm an asset protection planning attorney. I practice in Los Angeles. I started my career as a tax lawyer, and you do need to have a fairly strong tax background to be able to practice asset protection planning, because you are always moving assets around and you are always creating some sort of tax consequences, income tax, gift tax, whatever, property tax in some places. So the tax background is very important. An estate planning background is helpful. But I've been practicing almost exclusively in the area of asset protection planning for over 20 years now. Completed a couple thousand transactions, lots and lots of clients. So I have seen it all. I have done it all. And in my presentations, I try not to hold anything back. I do not keep any secrets, maybe rarely something that maybe gives us a competitive advantage. But generally speaking, I love to share everything that I know that I think will be useful to you in my presentations. But again, because we only have an hour together today, there's only so much we can cover in 1 hour. So let me know what it is you'd like me to focus on if there's anything, and I'm happy to detour there. So we'll start off the presentation today with just kind of a very brief, very quick introduction to asset protection planning, talk about some fundamental concepts that I think are super, super important in any form of asset protection planning. I think it's so, so important to keep your eye on the ball, to know what your intentions are, what your goals are, what may be possible, what may not be possible. So we'll start there. We'll talk about some common misconceptions, some interesting kind of general themes in asset protection planning, and then we'll go quickly into offshore planning, and we'll spend the vast majority of our time talking about offshore planning. So let's start off talking about some fundamental, foundational asset protection planning concepts. So first of all, and I think most importantly, and I think this probably most importantly for this entire presentation, which is, what is the goal of the asset protection planning, right? What is it that we are trying to accomplish when we are engaging in any form of asset protection planning? So the goal, despite the name for this area of the law, is not asset protection, right? It's not to protect assets, because usually that is really difficult to do, and certainly in an absolute sense. It's very difficult, maybe often impossible, to protect assets like absolutely categorically, right? 100% bulletproof type of asset protection. So if that is not on the table for us, then what is the goal? Well, the goal is to improve your negotiating position, right? The goal is to make it so difficult and so expensive for any plaintiff, creditor, or whatever government agency to go after your assets, your client's assets, that it will change their negotiating position, right? And will allow our client, who is usually the debtor, to settle on much better terms with their plaintiff or creditor. So that's our goal. And because the goal is not to make assets unreachable, I want you to keep that in the back of your head as we have our discussion today, as we talk through different structures, because whichever structure we're talking about. And this applies equally to domestic asset protection planning, offshore, but whichever asset protection structure we are talking about, you will usually notice that maybe there is something about that structure that is not perfect. There is some vulnerability, right? There is some way you can criticize that structure. And I think keeping in mind what is our ultimate objective, right? Improving our negotiating position, that is key. So the structure that we're looking at, maybe it's not perfect, but does it improve our negotiating position, right? Does it make it more difficult, more expensive for someone to come after our client's assets? And then what are the other options that we have, right? And no asset protection structure lives in a vacuum, right? Whether it's domestic or offshore. We're always comparing the different available structures to protect a particular asset. And usually when we're speaking to clients about, the different options that they have to protect assets, we tell them that there is no like one perfect way to protect an asset. Like offshore planning that we'll talk about, it is not some sort of a magic bullet, right? The different options that we have give us a different trade-off, and it's the trade-off between the level of protection on the one hand versus cost and complexity on the other hand. So just to give you a super simple example, let's say a client wants to protect money in the bank, right? They have money in a bank account and they want to protect it. And let's say we're looking at two options, right? One option would be to set up a Wyoming LLC and transfer the bank account to that Wyoming LLC. And the other option is to set up some sort of an offshore structure and move the money offshore. While both of them will give us some level of protection. But the offshore structure, as you'll find out in a bit, is going to give us a lot more protection than a Wyoming LLC. So why would any client ever look at a Wyoming LLC? Well, because the Wyoming LLC is much simpler to set up. It is much less expensive. There are less hassle involved. There's no tax complications involved, right? There's less of a feeling of discomfort for some clients because they're doing something domestically in the US and not something overseas. So we're looking at all these different trade-offs and we are picking the appropriate structure. So please keep in mind, what is our objective, right, in asset protection planning in general? And then given that objective, looking at the different options, looking at the different trade-offs, we're not looking for a perfect structure, right? We are looking for the structure that makes the most sense to this particular client. And each client is going to have a different trade-off among those variables. So asset protection planning, it's not about, a bulletproof form of protection. It's also usually not about hiding assets. Even though a lot of clients come to us believing that asset protection planning is about hiding assets. And perhaps, for some of them, that may be their objective, that they want to hide assets. For some of them, it's just something that they heard, and they're really looking to protect assets and not per se hide them, but they believe that hiding is sort of a necessary element of protecting. And in my experience, hiding assets or making assets difficult to find, it's not a bad thing, right? Because maybe if the plaintiff cannot discover your asset, maybe they'll never bring the lawsuit in the first place, or they will be a lot more willing to settle because they believe there are no assets to go after, or they believe there are assets, but they will not be able to find those assets, right? So that's not a bad thing. But it's not something we can rely upon, right? Because there are different tools and remedies available to creditors to find assets, from debtors' examinations to private investigators to database searches, what have you. So we always tell clients, do not rely on hiding assets alone, right? There must be a substantive form of protection. We always tell clients to assume that the plaintiff will know exactly what their assets are, exactly what was done to protect those assets, and there must be substance to the asset protection structure. So we're not trying to hide. So a question that comes up very often in asset protection planning, and again, this applies equally to both U.S. and offshore structures, and that is, when is it too late to protect assets? And this is something that you will notice often across the board in asset protection planning, which is clients seek to engage in asset protection planning when something bad has already happened, right? It's very rare that we will see clients engage in asset protection planning on a prospective basis. Oh, what if just in case something bad will happen one day? Let me set up some structures. Most people go through life, believe that other and believe ignorance, sort of a lazy approach to planning, where they think, oh, it will continue to be like that, and bad things will never happen to me. So most clients who come to us, they're caught by surprise, or if it's not surprise, still they haven't done anything to prepare, right? So usually when we see clients seeking asset protection planning, they either have already been sued or they're about to be sued. They already defaulted on a loan, on a personal guarantee. They already got some sort of a letter from some government agency that they're going to be investigated, and so forth, right? They are somehow on notice or entirely acting after the fact. So the question that comes up all the time in that context is, well, isn't it too late to protect assets if we're doing this after the fact? And the answer is, it could be too late, right? And it depends on a number of variables. So, and I think, as you will see in a second, this is where offshore planning comes in, right? So when we engage in asset protection planning on a last-minute basis, right, sort of after the fact, a plaintiff, a creditor, will have the ability to argue that what the debtor did should be voidable, right? It's what's called the voidable transfer, what we used to call a fraudulent transfer, now called voidable transfer. And the voidable transfer gives the plaintiff, the creditor, the ability to unwind the transfer, right? To return the transferred asset back to the transferor, meaning back to our client, to the debtor. So it makes the transfer ineffective. So given that the plaintiff has the ability to make an argument like that on last-minute transfers, isn't it too late to protect assets? And the answer is usually that it's not too late. Because even if you're doing this on a last-minute basis, even if the plaintiff has the ability to bring a fraudulent transfer, voidable transfer challenge, it doesn't mean that they will, right? Because it costs money, takes time, effort. Even if they bring a challenge like that, there is no guarantee that they will be successful. And even if they're successful, you know, what's the downside to the client? If the client was going to lose all of his assets anyway, right? It's some sort of like bet the farm type litigation. You know, there is no downside to then having another cause of action for a fraudulent transfer being added. You know, they're going to lose everything anyway. So we will definitely take it into account. And sometimes, you know, we will just know that there's just no chance of any asset protection structure working, and we're not going to touch it. We're not going to try. It's just going to be a complete waste of time and money. But in some cases, it's like, hey, you know, yeah, maybe it will not work. Maybe the plaintiff will be aggressive, but what's the downside of trying, right? And for a lot of clients, there is no downside of trying, and the worst that can happen is it's not going to work. And I have countless stories where we thought that the asset protection planning we're doing for a client has such a minimal chance of working, and the plaintiff just walks away. They don't want to deal with the asset protection structures, or they settle, and they settle for this much instead of like for all that money they were asking for originally. You know, as I remember Wayne Gretzky used to say, 100% of the shots you do not take do not go in. All right, so take a shot. The worst that can happen is it's not going to work. Okay, so let's get into offshore let's get into offshore asset protection planning. And let me get you there the following way. So in asset protection planning, our fundamental goal is to take an asset that our client owns and make it into an asset that our client does not own. And because a plaintiff can take from you, a creditor can take from you those assets that are yours, right, that you own, and they cannot take from you assets that belong to someone else. So every single asset protection structure aims to take an asset that our client owns and make it not their asset. And of course, the tricky part is to do it in such a way so that the client retains control over that asset, right? Clients really, really want to retain control over their assets, perhaps retain the ability to transfer the asset back to the client's name when they are ready to do so, once all the litigation, let's say, is behind them. We would like to engage in all of these transfers of assets, usually without any tax consequences, right? Without any income tax, estate tax, and so forth. So every single asset protection structure, that is what we're trying to accomplish. Take an asset that the client owns, make it into an asset that the client does not own. And as I said, there are a lot of options. There are probably a couple dozen different structures that we use on consistent basis to protect different types of assets. And for different types of assets, there are going to be different options we're looking at, right? So if a client comes to us and says, Jacob, I want to protect money in a bank account, right? We look at these options. And if they are trying to protect real estate, it's something different. And if they're trying to protect their business or a professional practice, intellectual property, art, on and on and on and on, right? So for different types of assets, we may be looking at different approaches to protecting those assets. And then our job is to educate the client about these different options that he has, explain the trade-offs to the client, right? The relative level of protection, costs, complexity, headaches, things like that, and allow the client to pick an approach that makes the most sense to them. So, and that's where offshore planning comes in, right? It's one of the forms of asset protection planning. It's one of the available structures. It's not the only one. Well, it is the only one if you go to some asset protection service providers. That's all they will try to sell you, I guess, because they can charge more money. But it's one of the available planning options, and it's not a planning option that applies to every kind of asset. So let's say that a client comes to me and the client wants to protect a commercial warehouse, right, that they own somewhere in the United States. I'm not going to suggest that we transfer the ownership of that warehouse into an offshore trust. So first of all, that just complicates the client's life significantly, because now you have real estate in the United States where it is titled in the name of an offshore trust company, right, as the trustee of an offshore trust, which means that any further transfers of that real estate will require the signature of the foreign trustee. And how do we get their signature notarized, right? It becomes a giant headache. And second, does a U.S. judge care? Does a U.S. judge who has jurisdiction over that piece of real estate, does he care that we transferred ownership into an offshore trust or into any structure, right? So if the judge is going to respect the fact that the ownership of the asset has been transferred out of the client's name, great, then any sort of structure should work, domestic or foreign. And if he does not respect it, right, with the real estate, the judge can do something about it. With the real estate, the judge has jurisdiction over the real estate, and if he wants to, he can ignore the offshore ownership of that real estate. So in our practice, we use offshore structures only for those assets that can be made offshore assets, right, where the asset itself can be one day transferred overseas. Real estate cannot be transferred overseas. You can perhaps argue that, well, maybe we place the ownership of the U.S. real estate into an LLC, and then the LLC interest can go into an offshore structure. You can do that, again, back to the question of, will a U.S. judge respect that? I don't know, maybe not. But so primarily in our practice, and it's my recommendation to most practitioners, is to use offshore structures for liquid assets, for assets that can easily be made liquid, right? Where the asset itself can be moved beyond the jurisdiction of a U.S. judge. And really, that's what offshore is all about. We are looking not only to gain the advantage of the friendly laws of some other jurisdiction, friendly asset protection laws of some other jurisdiction, we are also looking to move the asset itself beyond the jurisdiction of a U.S. judge. I'll give you one of my favorite examples. I'm trying to remember the client story. I represented this client some years ago. For some reason, her case just kind of stuck in my head for a long time. So an older lady, I think she was in her late 70s, and her primary asset was her brokerage account. She had a few $1 million in her brokerage account. This is her entire life savings. She was, I guess, a fairly successful businesswoman, worked hard her entire life. And she retired, and she was living off of this, a few $1 million that she had in her brokerage account. She did something that, people tend to do when they have children, which is she decided to help her son when her son decided to become a real estate developer. And she signed a personal guarantee on his loans. I think it was like around $5 million that she guaranteed. The son ended up failing as a real estate developer. And the bank, was one of the large banks, came calling on the guarantee. And, this also kind of goes back to the question of, is it too late? Because as I recall, she went to a number of big law firms in New York and Chicago and LA, just trying to find some sort of help. And every law firm she went to told her, it's too late. There's already been a default on the loan. And because there has already been a default on the loan, anything you do now will be fraudulent transfer, as it was called back then, and it's not going to work. So we ended up setting up an offshore structure for her. It was an offshore trust with, I believe back then, money going to a Swiss bank. And she moved the money out of her U.S. brokerage account to the Swiss bank, which effectively is an investment management account owned by this offshore trust. And the bank never pursued her. They just never went after her. They didn't want to deal with it. I could never fully understand that decision by the bank. I mean, there was enough money at stake where they could have, at least applied some pressure to her to try to get her to settle. She probably would have happily settled for some amount of money that would not have left her destitute, right? But the bank just decided to walk away, right? And that's really the beauty of the offshore structures. It is the laws of the jurisdictions we are picking are friendly. The money goes beyond the jurisdiction of a U.S. judge. And I think equally importantly, the perception that someone going after this money will have is that we're going to have a heck of a battle getting at this money. Maybe it's not impossible. Nothing is ever impossible, right? But it's going to be an uphill climb, and we're going to spend a lot of money trying to chase these offshore assets. And our probability of success is probably going to be very low. Is it worth it for us, right? So that's usually the analysis. And I've been in some cases on the other side. That is usually the analysis that you go through as a plaintiff or a creditor. So offshore structures can be very off-putting for creditors and plaintiffs. Okay, I am required to read a code for those of you who are in New York. This is for you. This is only for attorneys in New York. Everyone else, go get some coffee, come back in 10 seconds. In order to comply with New York regulations, attorneys looking for CLE credit in New York will need to be able to provide a code. This code is not intended for the Cerify Legal Edge audience, either live or on demand. I will read this code twice and only twice and cannot repeat it or email it to you. So please make note of it. The New York State code number is JS351156045. Again, the New York State code is JS351156045. 6042. Okay. Moving on. Okay, so this was only for attorneys in New York State. So let's get into offshore structures kind of more specifically. We'll talk about jurisdictions. We'll talk about different type of structures and the like. I remember when I started practicing asset protection in the early aughts, the big thing was the Cook Islands. And, surprisingly, the Cook Islands is still the big thing. Primarily, I think, because of people's laziness or inertia. I know this is probably going to be controversial, but I'm going to go out on a limb and say that any asset protection attorney still using the Cook Islands today is just being lazy. So let's talk about the specific legal structures we use overseas. Let's talk about jurisdictions. So with respect to structures, the holy grail kind of a structure, right? The cornerstone of asset protection planning, the offshore, especially asset protection planning, is an offshore trust. So what is an offshore trust? So first of all, let's talk about asset protection planning trusts in general. So we set up way more domestic asset protection planning trusts than offshore asset protection planning trusts, right? We have over the years set up hundreds and hundreds of US-based asset protection trusts. So what's a US-based asset protection trust? So first of all, it's a trust that is irrevocable, right? The trust must be irrevocable, which is, of concern to clients. Clients want to retain control over their assets. And with an irrevocable trust, it sounds like the control is gone. It's you're making a commitment, right? It's cast in stone. And that used to be the case with irrevocable trusts. Certainly when I went to law school, when I first started practicing law, initially as an estate planning lawyer and then later as a tax lawyer, I recall that, an irrevocable trust was exactly that, as the name suggests. You commit to it, you do it, and you're done. And of course, over the past 15 years, I would say the legal community has developed the ability to allow the client to retain some form of control over the assets in an irrevocable trust. It's not direct control, that would not work, but it is controlled through a trust protector, right? So in an irrevocable trust, we appoint a trust protector. It's an independent third party, and this independent third party will have the ability to terminate the trust, change the beneficiaries of the trust, change any provision in the trust agreement, change the governing law of the trust, and so on and so forth. So that's a US-based asset protection trust. It has to be irrevocable. Again, not a scary concept anymore. And I do have lectures out there specifically on these types of trusts where we spend a lot of time talking about trust protectors and how that works. And I think I have a lot of these on YouTube or on our law firm's website. You can easily find those videos. So the trust must be irrevocable. There must be a spendthrift clause, which I think pretty much every single trust has nowadays. And the trust must be discretionary, meaning that the trustee of the trust must be given discretion when it comes to making distributions. We want to avoid mandatory distributions in an asset protection trust. And then finally, the trust usually should be for the benefit of someone other than the settlor, right? So if our client is setting up an asset protection trust, it should be for someone else's benefit. So it may be like the children of the settlor or other family members or the family poodle or what have you. The vast majority of states still do not allow what's called the self-settled trust. as an asset protection tool. Self-settled meaning you set up a trust for your own benefit. So like your living trust is the most common example of a self-settled trust. So an asset protection trust must be for someone else's benefit. And even there's now about, I don't remember the exact number, let's say about 20 states, maybe 15 to 20 states, if I'm remembering correctly, that do allow self-settled trust as asset protection vehicles. And even in those states, I'm usually not a fan of setting up a self-settled trust because I do believe that it would be easier for a creditor to pierce the corporate veil of a self-settled trust as opposed to trust you set up for the benefit of someone else. So my advice usually is not to set up a self-settled trust. So those are the trusts we set up domestically. How does this translate to offshore? Well, we're setting up the exact same type of trust offshore, right? So an offshore asset protection trust, it's irrevocable, it has a trust protector, spendthrift clause, discretion by the trustee, and for the benefit of a third party. And again, all of these offshore jurisdictions that are used for asset protections, protection, they do allow self-settled trusts. But again, I personally do not believe it's a good idea to use a self-settled trust. And also keep in mind that if the client ever has to file for bankruptcy, if you've transferred assets into a self-settled trust, there is now a 10-year look back and the ability to claw back the transfer, 10 years if you're transferring assets to a self-settled trust. So I do think that it's not a good idea to use a self-settled trust domestically or overseas, nor is there a need to if you have a well-developed trust protector within the trust. All right, so with an offshore asset protection trust, let's talk about where are we going to locate this trust. Well, we want a jurisdiction that has modernized its trust laws, so like maybe eliminated the rule against perpetuities. They all would have allowed self-settled trusts nowadays, and implemented all sorts of other debtor protections for trusts. The most important one being that we want a jurisdiction that will have a specific provision in its laws that states that this jurisdiction will not enforce a foreign judgment with respect to the assets of a domestic trust. So if you take, for example, let's go to the Cook Islands, since it's so popular on the internet, I think mostly, again, because of all the old articles that are floating out there, not such a great jurisdiction today. If you look at the Cook Islands will provide that, yeah, generally we will enforce a judgment from another country. But when it comes to judgments that somehow impact the assets of a trust registered in the Cook Islands or domiciled in the Cook Islands, then that judgment will not be enforced. And certainly that leaves plaintiffs in the lurch, right? Because you get a judgment against someone in the United States that someone has assets sitting in the Cook Islands Trust. How do you get at those assets if the Cook Islands does not recognize the U.S. judgment? You do not have the ability to litigate in the Cook Islands because there is no personal jurisdiction over the settlor in the Cook Islands, so it's difficult for the plaintiff. So these are the jurisdictions you are looking for, the characteristics of jurisdictions, right? And you want a jurisdiction that has not just modernized its trust laws, but you want a jurisdiction that has intentionally made its trust laws and perhaps debtor-creditor laws more friendly as to debtors, right? So a lot of these jurisdictions will shorten the statute of limitations for avoidable conveyance, for a fraudulent transfer, to 2 years. For some type of transfers, maybe even to 1 year, right? So that's lovely. Some jurisdictions build in other protections, like they provide that if there's what's called an event of duress, meaning there is a collection action proceeding against the settlor of a local trust or beneficiaries of a local trust, and the trustee makes a distribution to the settlor or the beneficiary under those circumstances, that the trustee is automatically disqualified as being a trustee. They lose their license as a trustee. So they put on all sorts of protections, right, for debtors. So the jurisdictions that people use frequently for offshore asset protection trusts, again, historically, it was the Cook Islands. A lot of people still use the Cook Islands. Other jurisdictions would be Nevis. We use primarily St. Vincent and the Grenadines. There are, certain other islands that are helpful both in the South Pacific and the Caribbean. There are some jurisdictions that are pretty nice in Europe, right? But these are the provisions you're looking for. Let's talk a little bit about the Cook Islands and why I am negative on the Cook Islands. There used to be a time, maybe 20 years ago, 15, 20 years ago, when myself and my former partner were the largest provider of trusts to the Cook Islands. We did a lot of business with them, set up a lot of Cook Islands trusts. It was great. It was a great jurisdiction, a great body of law. But things change, right? And you need to change with the times. So the laws in the Cook Islands have stayed the same, which in one way you can think is a positive. They didn't change for the worse. They didn't become more creditor friendly. But other jurisdictions have become even more debtor friendly, and the Cook Islands did not sort of continue that pursuit. So they kind of stagnated with respect to their laws. So that's one. Both, for example, Nevis and St. Vincent and the Grenadines copied the trust laws of the Cook Islands. So they're exactly the same. But like, for example, St. Vincent has in the past few years modified their trust laws again to make them even more competitive, right? And the Cooks, I think, just kind of relies on its jurisdiction and has not done anything like it. Cook Islands has a couple of great kind of big trust companies that a lot of people use, a lot of smaller trust companies. And because the Cooks was sort of the original offshore asset protection planning jurisdiction, what happened is a lot of the early case law with respect to offshore trusts and a creditor's ability to reach the assets of an offshore trust developed with respect to the Cook Islands trusts. And some of this case law is negative, right? It's not helpful to debtors. There's also, like our law firm actually had a case where a plaintiff tried to assert personal jurisdiction against one of the Cook Islands trust companies that represented our client, and they were successful in doing so. So we stopped using the Cook Islands about 15 years ago, approximately. It became, first of all, very notorious, right? It's hard to set up a Cook Islands trust and argue you had some sort of other reason for setting up a Cook Islands trust than asset protection, right? And also all of these negative things. So we set up our trust in St. Vincent and the Grenadines. We think it's a great jurisdiction. Nevis is also great. I personally prefer to use Nevis for my LLCs, my offshore LLCs, and I like as I'll discuss in a second, the LLCs and trusts to be in different countries to make it more difficult for a creditor. I mean, I still hear a lot of people talk about the Cook Islands there as the offshore asset protection jurisdiction. I think it's purely inertia. I think it's people being lazy. They Google it, and there's still a ton of articles back from the 90s and 2000s, right, about offshore asset protection planning, maybe even some of my early articles touting how great the Cook Islands are. And obviously, the articles still live there, and people still go with it. But I would recommend that, perhaps look into other jurisdictions today. But even the Cook Islands, listen, infinitely better, right, than, first of all, doing nothing, often much better than a domestic structure, and still better than the vast majority of just simply foreign countries, right? Given the choice between setting up an offshore structure, let's say in Canada, versus the Cook Islands, yeah, 100% I'm choosing the Cook Islands. They will not recognize the U.S. judgment. Their laws are very debtor-friendly, right? Compared especially to a country like Canada, which is going to be, which will recognize the U.S. judgment and which will have very similar debtor-creditor laws like the United States. In addition to offshore trusts, we may also use sometimes legal entities overseas. Usually these are limited liability companies. Again, just like in the United States, we do not want to use corporations for asset protection because the shares of corporate stock can be attached by a creditor, right? They can get a turnover order. With an LLC, we have the charging order limitation. The same is true with foreign LLCs, right? Nevis, for example, based its LLC Act on the Delaware LLC Act. So a lot of the protections you get in Delaware, you get in Nevis as well. So for some clients, although it's not as often as it used to be, we do use LLCs, and sort of the traditional offshore asset protection structure would be a foreign trust that will own a foreign LLC, and the foreign LLC will own a foreign bank account. So one thing is, if you do have a structure like this, trust, LLC, bank account, make sure that each of these elements are in a different country, right? You want to make it as difficult as you can for a plaintiff to go after these assets. So if the trust is going to be in St. Vincent and the Grenadines, then it owns a Nevis limited liability company, then perhaps the bank account is not anywhere near, right? It's in Switzerland, or it's in Panama, or it's in Hong Kong, or it's wherever else, right? We are able to set up a bank account for the client. Another structure that is used, maybe not as well, definitely not as often as the offshore trusts, and maybe a little bit less often than offshore LLCs, would be an offshore private foundation. So a foundation is kind of an interesting thing. It's something, it's not a trust, it's not a corporation, right? It's kind of its own thing, the foundation. But there are some similarities both to trusts and corporations as to how foundations work. And it gets us essentially to the same result, meaning that we are able to argue that once the client has placed her assets into this foundation, the client no longer owns the asset, right? The same argument we can make with the trust. Once the assets are in an irrevocable trust, the client no longer owns those assets. Foundations are interesting, especially in some countries. Like, for example, we set up a lot of foundations in Hungary because in Hungary, the local lawyers are able to structure the foundation in such a way so that there is no disclosure of beneficial ownership of the foundation to a government agency, to the tax authorities, to the central bank, and so forth. So for clients who really are looking for anonymity and privacy and discretion, a foundation may be a more interesting play than a traditional offshore trust. So with all offshore structures, there are some challenges. There are some kind of practical pointers we need to consider. So like one question, I'm going to think through some of the questions that clients ask us often with respect to offshore structures. And of course, the first question is control. And the second question is trust. So any conversation we ever have with a client about asset protection planning, first question, like almost 100% of the time, the first question is, how do I keep control over my assets? Because remember, almost always clients engage in asset protection planning because something bad has happened. This is not something they've always wanted to do, right? No one like wakes up in the morning, gets out of bed and says, oh man, I'm going to set me up an asset protection trust. That's going to be awesome. Always wanted to have one. I mean, maybe there are a couple of people out there like that, but usually it's a response to something bad happening. And remember, bad things never happen to them, right? They always happen to other people. And this bad thing that's going on right now, well, it's going to go away eventually. And once it goes away, I no longer need that structure. So it's important for me to retain control in the interim and the ability to reclaim my assets afterward. So first question is control. And just like with the domestic trust, we will use a protector to retain control for the client. So would we with a foreign trust. right? A protector can be appointed, and the protector will enable the client to indirectly retain control over the trust and its assets. Now, with a foreign trust, it's very important that the protector be someone outside the United States. We do not want the U.S. court to have jurisdiction, personal jurisdiction over the protector. And there is case law out there where when the protector is in the United States, the court forces the protector to remove and replace the trustee and replace the foreign trustee with a U.S.-based trustee, and then the court exercises jurisdiction over the U.S.-based trustee. So if you have a foreign trust, keep it all offshore so that there's nothing for a U.S. court to put their hooks in. So control we retain through the protector. Control is also retained by not, well, let's talk about that in the context of trust. So the next concern that clients have is trust, which is if I'm going to send my life savings to some foreign country that I cannot find on the map of the world, right, without like searching for it in Google Maps, like how do I get past the fact that someone in this country, I've never met them before, don't know who they are going to control, they're going to have access to my life savings. How can I trust them? Right? How do I trust this trust company we picked in St. Vincent and the Grenadines to control my assets? And that's a legitimate question, because certainly I'm sure the history of the world is replete with cases of foreign trust companies running off with clients' money, foreign banks or investment advisors running off with clients' money. I'm sure stuff like that happens. Fortunately, we don't see that often. I mean, almost never. But you still want to try to anticipate that and make it a non-issue. So how do you make it a non-issue? Well, that's where this multi-tiered structure that I referenced earlier comes in, right? So if we have a foreign trust, where the foreign trust company is the trustee, own, let's say, a bank account in Switzerland directly, then the foreign trustee must be the one signing on that Swiss bank account. And then they directly control the client's life savings, and that is troubling, it's unnerving, I have anxiety over that. But if we take this trust and this bank account, and between them, we interpose a limited liability company. So the trust owns the LLC owns the bank account. The client, the settlor of the trust, right? The client is appointed as the manager of the LLC. Guess what? He is now the one signing on that Swiss bank account. So the foreign trustee has no access to the underlying bank account. They own the LLC, right? They have the ownership interest in the limited liability company, but they have no control over the bank account. We may not even tell them. Usually we don't tell them about where this bank account is, so that they are not tempted. And the other way you give clients comfort is by telling them, hey, listen, we conduct ongoing due diligence on all of these service providers that we work with, right? We have personal relationships with them. Many of them we've been using for 10, 15 years, right? They've been managing lots and lots and lots of clients' assets, right? You're not the first one. And I think this is something that makes asset protection kind of a little bit unique. You know, we, like every other law firm out there, we have a lot of discussions about what AI is going to do to our law practices. And maybe AI someday will replace some aspects of an asset protection practice, like the ability to draft documents, prepare proposals, right, to do analysis. But AI cannot step into my shoes and develop the personal relationships, right, that I have with the offshore service providers that we've been using for years. The AI is not going to travel to St. Vincent and the Grenadines, right, to spend a couple of days with the directors of the trust company. It's not going to go to Europe to meet with the bankers and investment managers and so forth. And it's very important. Let's talk about an intermediate structure, and then we'll talk about, you know, where the money actually goes in Europe. So an intermediate structure, meaning what? So sometimes when we talk to a client, and again, from our point of view, with our experience, right, we say to the client, listen, you need to move your money offshore. You need an offshore structure because you have an aggressive creditor after you. The litigation is like tomorrow. You need that level of protection that an offshore structure will give you. Something simple, domestic in the US is just not going to cut it. And the client says to you, oh, I am hopeful this is going to go away. Or I'm really uncomfortable in using an offshore structure, right? Despite all of your assurances. So there is a way of getting them there where we will start off with a US-based structure, so US-based trust. Well, we almost always, if we can, we will set up a trust for a client, because with the trust we can, really say to the other side that, hey, the client no longer owns his assets; it's now owned by the trust. So we'll set up a US-based trust, and we will include in the trust what is called, commonly called a trigger. So a trigger is the ability that someone has, usually it's given to the trust protector, to switch the trust from being a US-based trust to being a foreign trust, right? So the trust protector activates the trigger, and the trust changes its governing law from, let's say, Nevada to St. Vincent and the Grenadines. The US-based trustee is automatically removed. There is a successor trustee appointed in St. Vincent and the Grenadines. They step up to the plate. And then usually in our trust, we include replacement articles. So certain articles of the trust will be automatically replaced with new articles. And these new articles are drafted for an offshore trust, right? An offshore trust will read usually very, very differently from a US-based trust. So the trust protector kicks in the trigger, and the trust migrates to an offshore trust. And it's really cool to be able to do that because the client sets up the trust when he sets it up, and he funds it when he funds it, and then time starts clicking, and perhaps the statute of limitations and challenging that runs out. Or at least the funding of the trust predates a creditor's claim. That's wonderful. The migration of the trust to offshore is done by the trust protector. It's not done by the client. So there's no further action that a client needs to take that can be challenged by a creditor. So a trigger trust is something that we do use often when clients are not willing, to go offshore immediately. And then, like, what do we do with the actual with the money? Where does the money go, right? And that has become so challenging. It is probably the most challenging aspect of our practice. So it used to be, some 15, 20 years ago, when we would have a plethora of Swiss private banks fighting over our business, right? And I would go to Zurich all the time and meet with these banks and have relationships and send them lots and lots of clients. But the two things then happen. One is in 2008, the US government went after UBS for helping US clients avoid paying their US taxes. And there was a big settlement. And as a result of that one settlement with UBS, there was this cascading effect where all foreign countries, or almost all foreign countries, now provide to the United States Treasury information about Americans who bank in their countries, right? And all the local banks provide that information as well, either directly to the US Treasury or first to their local tax agency, and then it goes to the US Treasury. So now all foreign banks, right, communicate with the IRS, and that's fine, right? Our clients are not tax evaders. They're protecting assets from claims of creditors. But because of this requirement, it has become really expensive for banks in foreign countries to take on US clients. So after 2008, the vast majority of foreign banks have stopped accepting US clients. They just stopped, right? All these Swiss private banks we used to work with closed their doors on us and said, "Nine." The few banks that are left, and there are a few banks that are left, first of all, we need to eliminate those foreign banks that have branches in the United States, right? So we cannot be with UBS, we cannot be with HSBC or BNP, right? Because even if you set up an account with these banks outside the United States, because these banks have extensive business operations in the United States, it gives the U.S. court significant leverage over these foreign banks, and they can force the banks to levy on our clients' bank accounts. So we always want to work with a foreign bank or investment manager that has no presence in the United States, right? That's number one. Number two, because there are now so few banks left that will take U.S. clients, the ones that are left have very high minimums, right? Most of them are $1 million plus to set up an account. And also what we found from our experience working with Swiss banks is that Swiss banks, I mean, they're very credible. You know, they, you know, very dependable, very expensive from the standpoint of fees, but okay, fine. But the big negative in my experience with Swiss banks is when things go pear-shaped, they will all roll over on their backs and pee on themselves. They're, pardon my language, they will always look after number one first, right? And they will leave the client dangling in the wind. So we have found since then investment managers in other countries that actually stand up for our clients, that will fight, that will litigate with the creditors, right? And will not simply roll over when creditors come calling. So we in our practice, we've stopped using the Swiss banks, or maybe we'll use them like very, very infrequently. And even though we call them banks, even the Swiss like private banks, they're not really banks in the way we Americans think of as banks, right? Swiss private banks are really investment management firms, right? They're more like a Morgan Stanley, Merrill Lynch type of an outfit than like Chase Bank, let's say. So they're all in the business of investment management, and because they're in the business of investment management, it does allow us to find other investment managers out there overseas, right, that can manage our clients' investments. And again, we are looking for institutions that are large enough, credible enough, where the client has peace of mind, but where they do not have any branches, employees, anything else going on in the United States. And then finally, quickly, offshore structures do have tax reporting obligations. You know, you're not paying an extra level of tax, an extra layer of tax, but there are disclosure requirements that the IRS expects, right? We have to disclose foreign trusts by filing Form 3520. We need to disclose foreign LLCs. We need to disclose foreign bank accounts. You know, that's separate filing with the U.S. Treasury, the FinCEN form, I think FinCEN 114. So there are all these disclosures. And again, our clients are not hiding money from the IRS, so there's really no downside to disclosing other than the hassle, the cost, the time that it takes to prepare these forms, you know, the cost of having the client's accountant prepare these forms, and so forth. But remember, most clients, again, they're seeking asset protection because something bad has already happened, right? They're going to lose maybe not everything that they have, maybe a significant chunk of what they have, right? Sometimes all of it. So you need to prioritize your concerns. Like, what is the number one thing you should be concerned with? Well, the number one thing you should be concerned with is keeping what you have, right? Keep your assets, because if you don't keep your assets, everything else is a moot point. And once we figure out a way to keep your assets, well, then let's talk about other things. Let's talk about the different investment options you will get, you know, with these offshore financial institutions. And let's talk about the fees they're going to charge you, right? And let's talk about retaining control over the money, and let's talk about a myriad of other things. And also a reminder, again, most clients who seek asset protection, they're protecting against this one specific thing that just happened to them. They may not want to keep a structure long term, so maybe they keep it 2, 3, 4 years. Once this litigation is behind them, they settled. All right, they're gonna unwind the structure we have set up. There are clients who set up asset protection plans like prospectively, right? Just in case something bad happens, or they've seen their competitors be sued, or they expect that, hey, maybe at some point the economy will turn and the lender or the landlord is going to come calling in the personal guarantee that I signed, right? So there's a whole host of clients that they're very different approach to planning. And, you know, for us, offshore asset protection planning is maybe a good like 20% of our practice. Not because the structures are not great. These are fantastic structures. I've never, ever in my entire career had any plaintiff, including 3-letter government agencies, reach assets that are overseas, right? It's just the offshore structures are best suited for liquid assets. And, you know, most of our clients, and I'm sure most of your clients, have their wealth in real estate and their businesses, which are not that liquid. So I'm Jacob Stein. You all have my materials, has my email address in the materials. I always welcome questions from anyone who's taken my courses. So if you have you know, anything I didn't cover or didn't understand what I was covering, I'm happy to answer your questions. If you have clients who need asset protection help, very happy to speak to your clients and try to help them. And with that, thank you so much for listening. I appreciate it. See you guys in another seminar.